Hello, I'm Joe Deems. This is the first part of my two-part interview with Senator Ben Nelson. Senator Nelson, welcome to our show.
Thank you, Joe. It's a pleasure to be with you today.
Let's start off with an easy question to begin with. It has to do with philosophy. Are there any differences, Senator, in the NAIC regulatory philosophy as such relates to captive insurance companies, say, versus the traditional insurance industry?
Well, the introduction of captives as a means of insuring a particular company's risks was somewhat recent, but has been going on for some period of time. In other words, companies found a way to maybe reinsure or place their risks in a captive for the spreading of risk concept that insurance generally involves. But what's happened is in some instances those captives have been expanded into providing risks protection that is traditional for traditional insurers. And that has raised serious questions about whether or not captives should be utilized in that fashion. Now, if they engage in traditional insurance activity, now they will be looked at as providing insurance for risks and outside the parent company. So if it's going to become traditional, then the question is, should it be treated as a captive or treated as a risk retention group, or should it be treated in a more traditional fashion? I think the regulators are concerned that captives are now potentially insuring risks that go beyond the risk of a parent company.
So having said that, if I could narrow us down just a little bit more, what is the NAIC's regulatory philosophy insofar as it relates to risk retention groups, Senator?
Well, the NAIC believes that there's a place for risk retention groups. If we go back to the beginning of risk retention groups, they developed in part because there was an absence in the traditional market for certain lines of coverage, medical liability, for example, being one of them, or products liability ultimately, and other kinds of coverages that just weren't available. But some of the risk retention groups began to branch out into other areas where there really wasn't a need because of the absence of a market. There were markets available for auto warranties, for home warranties, and the like. And as a result of some notable insolvencies where RRGs were branching out in other areas, it cast sort of a doubt and a shadow over those risk retention groups that were doing their level best at providing the markets that were necessary for insureds that were not available in the traditional market.
Are there not instances, Senator, where we have seen where state regulators have in fact misinterpreted the provisions of the Liability Risk Retention Act?
Well, obviously, because these misinterpretations, as you call them, have been challenged in court, I think maybe the risk retention groups have established that regulators are not infallible, but the court is infallible. And so when you have those different interpretations that one party thinks is a misinterpretation, one of the better ways of resolving those is through the legal system, the court system, and that has been utilized. It's also, I think, important that in some instances, before everything gets to that level, that discussions between risk retention group entities and regulators is an important way of resolving differences as well. And then if you can't get them resolved in the informal fashion, then there is a formal remedy available to both parties for that matter.
We agree completely. You know, and my final question for this session, Senator, and that is, does the NAIC actually have a list of what you consider to be potential challenge areas involving risk retention groups?
I don't think that there's a list, but I think I could generally say that if the risk retention groups stay within the risks that are right now traditionally available to them, some by law, but also by implication, that there is not going to be a problem. But to try to expand it to go beyond those into the traditional field is a challenge. There's been law or a bill that's floated around for a couple of years back here to try to expand the reach of risk retention groups, and that doesn't seem to be going anywhere. It would be better if the risk retention groups came in and talked to the commissioners, talked to the NAIC about that particular approach, rather than to try to go around the NAIC, around state regulators to Congress. It's not that you don't have a way to go through Congress, but it might be better in terms of finding solutions if, rather than going to Congress first, coming to the NAIC and to the states first.
That's a very good answer, Senator. In fact, that you gave us a little prelude to your answer to another question I'm going to ask during the second session. But I want to say this. I want to thank you very much for being our guest today. And I want to also thank members of you, our audience, for watching this interview on WRIN TV.
Thank you.